Hello everyone and welcome to Thorough Newspaper Analysis. Let's see that what all we will be discussing today. Firstly, we will be discussing the article from the Indian Express which is titled as When Helping Hurts. So basically, as we know that the government is making initiatives to increase the marriageable age for women and to bring it at par and with the boys to be at 21. So basically here in this article, the author has tried to explain as to what could be the negative impact as to how this help could actually hurt the various women who belong to the lower section of the society and especially to the Adivasis and SCs and ST groups. Secondly, the contempt case, the Mulgaonkar Principles. So basically, as we are like at length, we have been discussing the contempt case and how far is it feasible to have criminal contempt as an offence regarding the Prashant Bhushan case. So here, as we know that one of these judgments of Mulgaonkar cases, so there were some principles laid in this case regarding the contempt. So we will be discussing them at length today. And thirdly, we have the news and flash column where we'll be discussing the crisp pointer news which are more important for our prelims exam. And kindly, please just please pardon me for my voice and low energy today. I'm not really feeling very well. So please bear with me with my grumpy voice for the day. I hope that it'll not be that big a trouble. So yeah. So let's discuss about, first of all, let's see some courses that we have at LawSikho for you. We have the lot of the courses that actually is our judiciary test prep course, wherein you can avail best of the coaching and guidance if you're preparing for the judicial services exam. And you can visit the landing page. We have the link of this landing page there in the description box. And you can download free study material regarding various subjects that are there in the judicial services. And you can obviously have a look at the other courses that we have for CLAT, All India Bar Exam, etc. We are very shortly coming up with a full-length SEBI course as well as UPSC Law Optional course as well. So you may also have a look at them once they are there. Now let's see that what is the multiple choice question for the day. Which of the following is the official mascot of the Thumbi Mahotsav 2020? So basically, this is a festival that is to be celebrated in Kerala. I'm giving you a small hint. We'll be discussing about this in the further slides. So basically, what is the official mascot that they have chosen for this? First, Shera. Second, Stumpy. Third, Pantalu. Or D, Bholu. So there might be a chance that you might not be able to answer this right now. So just keep this question in mind and keep a track of what we are discussing in our content today. So surely we'll be able to answer it. So this is the descriptive question for the day. Discuss about contempt jurisdiction of the courts in the light of Mulgaonkar Principles. So as we know that many a times cases are also directly asked in our exam, and since criminal contempt is so much into news, there is a very high chance that a question from contempt and directly asking the Mulgaonkar Principles or Mulgaonkar case might appear in the exam. With this, let's start the discussion for first article for the day, which says that the increase of marriage, and then let's see that what impact would it have on Dalits and Adivasis. Now, as we know that the government has, it is thinking in the direction to increase the marriageable age of women, and actually the author says that this might or might not do some benefits to the women at large, but it will definitely end up criminalizing and exacerbating the existing vulnerabilities of Dalit and Adivasi communities in rural areas. Basically, as we know that the condition of the Dalits and Adivasi communities in rural areas is already not very good. And if we talk particularly about the women in these groups, then also it is even worse. And then the author says that if we end up increasing the age of marriage, so instead of doing anything good that it could have done, it will actually criminalize and further deteriorate the condition of the Dalit and Adivasi women in rural areas, and it will not at all empower them. Now let's see that what could be the reasons behind such contentions of the author. Firstly, there is a casual link between education and age of marriage. Now here a very beautiful comparison has been drawn, and it says that the education levels impact delayed age of marriage, and this is according to the National Family Health Survey number 4. So basically, according to this survey, it has definitely said that there is for sure a relationship between education and age of marriage. But Here it noted that it never happened that if we increased the age of marriage, then the situation of education improved. Rather, it was the opposite thing that was happening, that if a woman or a girl was educated or was enrolled into any kind of education or was availing any kind of education, then her age of marriage, it actually got pushed. So though legally it was 18, but then also she's not getting married at the age of 18, since she's into her college or she's pursuing a job after that. So basically, education has made the age of marriage to push further, but vice versa is not possible, which means that age of marriage, if we push it forward, then it might really have no effect on the education level, and it might still remain the same. So basically, National Human Rights Commission 2018 report stated, and it reiterated this causal link. Always keep in mind, please always keep in mind that such resources like National Human Rights Commission, National Family Health Survey from 4, or any survey for that matter, these are very authentic sources. And anytime you're discussing any answer in the mains as well, or there is a question related to this in the essay part of your exam, then such things must be quoted, and that is why it will make your answer a different one from the others, because obviously the basic things will be given by all the writers, all the aspirants, right? But the examiner is looking forward to something very eye-catching that can actually substantiate your answer beyond any doubt. So these are those reports and indices, those facts that actually can make your give you those brownie points that we are all looking for. Then here the step needed is that we address gendered and caste-based disparities, and we should practice more into the principle of social justice. Secondly, wealth quintile data. So basically the quintile basically means any group of people or any group of the society, any section of the society. So basically the lowest section of the society, that is 45% of the scheduled tribes and 25.9% of the scheduled caste households, are most likely to marry their girls early out of socio-economic necessity. Now, just as even yesterday we discussed this point, that poverty, the author had said that poverty was the biggest reason that we needed to address, and if we would address poverty successfully, then there would be actually no need to increase the marriageable age for women. And if the households, the parents of the girl, they will not be poor, that poor, they will definitely not marry off their daughter at such an early age, and they will not consider it as the so-called burden that we take up as a girl to be in our society many a times. So here also, according to the wealth quintile data, like if we compare the economic status of the socio-economic necessity, we should work more into elevating this, socio-economic status of these families, especially of the SCs and ST, and that would actually help the girls to stay at home for a longer time. Third, schooling data. So this is again according to the National Family Health Survey number 4. So it says that 42% of the STs and 33% of SC women of age of 15 to 49 have no schooling. This is actually a very huge number and very huge proportion also that are that are exempted from education, which should not be the case, because now we have the right to education, and we further have an extended window up to 18 years, like 6 to 17 years, and only in here also, like as we know, after the national education policy, there is this proposal to increase the age for the schooling and education also. So basically here only 8% of the rural girls, which are 16 to 17 years of age, cite marriage as a reason for dropping out of school. So that is actually still a big number to say. Now fourth, increase in child marriage. Now, as we know, between 2005 to 6 and 15 and 16, child marriage for girls have decreased from 26.5 to 11.9, and this we should keep in mind that we have made continuous efforts, firstly to stop child marriage, and secondly to give them more and more education. And that is why it is important for us that to curb this, again we should work on their socio-economic status as well as education. And fourth, this is the fifth point, please consider. Increase the existing hurdles of young women to access reproductive and sexual health care, obviously. Because, there are a lot of social taboos, social stigma that, even in the times of, for various things, like in the case of their menstrual days, when they're not even, think that using some sanitary napkins or other things is actually very bad, and they consider it to be as very demeaning. And this actually definitely is not the case. And even in the times when they have any kind of sexual queries or queries related to their pregnancy, they do not have the right platform to approach to, and this social taboo should be broken for them if at all we really want to work in their nutrition and health, and their sexual and reproductive health. And finally, according to the 18th Law Commission report, which now again is very substantial resource to quote in our exam, it recommended the uniformity in the age of marriage at 18 years for both men and lowers and lowering the age of consent to 16. So it was reiterated by Justice Verma committee, and basically it said that there is no point having two different ages, marriageable age for men and women. You could have it as 18, and the marriage, like the age of consent, like for any kind of sexual activity or the other, can be lowered down to 16 years, and it was further reiterated by Justice Verma committee. Now let's see that what are the legal frameworks that are available. Now we already know that a Prohibition of Child Marriage Act 2006. Now according to this, both man who marries a girl below 18 and parents of minors who abet can be imprisoned for 2 years. And then protection of, which is the POXO Act, which is very very famous, Protection of Children from Sexual Offences 2012 Act. So it says that healthcare provides are to mandatorily report any case of under 18 years old who are found sexually active with those older than this age. So this was all for this discussion. Let's discuss the next article for the day, which talks about the Mulgaonkar Principles. Now, as we know that the criminal contempt case is very much highlighted these days due to the Prashant Bhushan's contempt case. So actually, he had given 2 tweets, and which are now considered by the judiciary and especially the top court of the India to be as hindering the working of the judicial system somehow, and that is why a case of criminal contempt has been initiated against him. Now let's see that what basically are the Mulgaonkar Principles. Firstly, the principles for exercising the contempt jurisdiction in S. Mulgaonkar versus Unknown in 1978. Let's see. So by a majority of 2:1, the court had held Mulgaonkar. So basically, Mulgaonkar was the editor of the Indian Express, and he was held not guilty. Please keep in mind that he was held not guilty of contempt, even though the same bench initiated the proceedings. So basically, in the beginning, this was the very bench, this 3 judges bench, this was the very bench that in the beginning had initiated this criminal contempt proceeding against Mulgaonkar, but in the finality, they actually came with a decision of the majority of 2:1 that he was actually not guilty of contempt. Now, here is a short background that the proceedings were initiated after some articles were written about certain, like they were actually criticizing certain judicial decisions during the emergency as they were taken. Now, as you can see, this case is from 1978. In 1975, we had the national emergency, which the then Prime Minister Indira Gandhi had invoked. And then it was initially the Supreme Court Registrar wrote to the editor seeking retraction and an apology. So it was later refused. So basically, the more important part was that what was the ruling, or basically what were the principles that were laid down in the case of Mulgaonkar regarding the criminal contempt. So first, wise economy of use by the court of its contempt jurisdiction, which means that as we have always, we have been discussing this time and again, that the courts should not be oversensitive regarding its own dignity and prestige, and it should actually bring into action or use its jurisdiction regarding criminal contempt with economic use, with a proper use, and it should not be like arbitrarily using every now and then against every criticism that is made. So basically, the court should not be oversensitive about their dignity and should be very practical when it comes to the use of its contempt jurisdiction. Secondly, a court with act where justice is jeopardized by gross or unfounded attack on the judges where attack is calculated to obstruct or destroy judicial process. Now here as well, in this case of Prashant Bhushan also, the main contention that is being laid in favor of Prashant Bhushan is that were the two tweets that were made by Prashant Bhushan, were they even of the capacity to actually destroy the judicial process? Because many of the supporters of Prashant Bhushan are saying that no, they were actually, they can be considered to be as fair criticism, and they were not at all with either, not with an intention, and also neither with an intention, and nor they actually had the capacity to destroy the judicial process, and thus they were not an unfounded attack, and they cannot be considered to be as of the capacity to destroy the judicial process, and thus the court does not really need to act or move into this criminal contempt jurisdiction. Thirdly, the court is willing to ignore by a majestic liberalism trifling and venial offences. So basically, just like point number 1, and it says that the dogs may bark, but the caravan will pass. So basically, it's like you need not consider everything that is being spoken about the court unless it is of very grave sensitivity or very grave nature. Now here, please don't consider this saying or this quotation or this this proverb to be as that everyone who criticizes the government will be someone who is barking like a dog. Please, this is just not the meaning of this. It simply means that there will be many people who actually, they will say a lot of things. Like, we say that people have this work of saying, and you really should not bother yourself with everything that they say. So obviously, if there is a case of fair criticism, then definitely, it should be respected and it should be taken very positively by the government institutions. But, if there are some elements who, just, uselessly try to do this and still, they're not able to destroy the judicial process, they should simply be ignored. And for an institution as prestigious and highly looked upon like the Supreme Court of India, it should focus more on delivering effective judgments and being active in ensuring the human rights and the fundamental rights to its own citizens. And fourthly, harmonize the constitutional values of free criticism and the need for a fearless curial process and its presiding functioning. So basically just the same thing, they're reiterating more or less the same thing. So this was all. So all these guidelines should be kept in mind, or these principles should be kept in mind, and they will have to be quoted in today's descriptive question as well. Now let's see that what do we have for news in flash today. Turkey to convert another church. Now, as we know, very recently, not even a month ago, the president of Turkey, who is Recep Tayyip Erdogan, it's his name. So he had actually converted a very historical site, which was Hagia Sophia. Basically, it was a museum. Earlier, it was a mosque, then it became a church, but then after it became museum, it was considered to be as a symbol of unity and symbol of secularism that was in some or the other way existing in Turkey. But then he converted Hagia Sophia into a well-functioning mosque, and also this should be remembered that Hagia Sophia also is a UNESCO World Heritage Site. So this was very criticized all over the world, and further it has criticized it has been criticized by Greece, that we discussed yesterday, that due to the Eastern Mediterranean or the Asian Sea matter, due to their coinciding exclusive economic zone claims, they are not at all liking these steps that are being taken by Turkey. And now another Orthodox church is being converted back to a mosque, and the name is Karye Museum. So basically, some of them, it is also known as the Chora Museum or the Chora, Chora Museum. You can also refer to this, and it is also known as Karye Museum. So it was after 1453 conquest of Constantinople by the Ottoman Turks. Basically, Constantinople was the ancient name for Turkey and the nearby area. Then second, Kerala's first Dragonfly Festival. This is really important for our exam. So the Worldwide Fund and India Kerala unit, in collaboration with the Society of Ordinate Studies. So, generally you should keep it in mind as to who all are organizing this Dragonfly Festival. And Thumni Puranam to organize the first state Dragonfly Festival called Thumbi Mahotsav 2020. And this Pantalu is the official mascot of the festivals. Basically, mascot is any kind of lucky token or lucky anything, any representative of something that you consider to be as lucky or a good sign of something. So it is a Pantalu. Third, Project Lightspeed. It is a project under which US pharma giant Pfizer and German biotechnology company BioNTech are testing 4 vaccine candidates for COVID-19. So basically, two of the gender candidates, BNT162b1 and BNT162b2, are in the phase of half of human trials in US and Germany. Basically, you do not need to remember it so technically. These two vaccines, these vaccines should be kept in mind, and that to what Project Lightspeed is related, because they might give you very related sounding to say options, like it is related to something space, some energy, something like that, but actually it is related to development of vaccines for COVID-19. So this was all for today. We hope it was an informative session for you. Stay tuned with LawSikho, and thank you so much.